SJC-11444, Commonwealth v. Lesterandre Bell.
So Brian, give us a second until clock going, and then you can proceed. All right.
Good morning, Your Honors. May it please the Court, Leslie O'Brien for Lesterandre Bell. The defendant's first argument concerns the denial of his Sixth Amendment right to effective assistance of counsel based on the trial judge's interference with trial counsel's closing argument. Counsel had argued that the gasoline can that was found in the defendant's apartment had been planted there. The prosecutor objected, and the judge not only sustained the objection, but gave a very forceful instruction to the jurors. He told the jurors, "You are to disregard that argument. There's been no testimony that the gasoline was planted. It is improper argument. You will disregard it." And then shortly thereafter, when defense counsel had finished his argument, the judge again addressed the jury. He had a recess, brought the jury back, and to emphasize his point said, "An attorney is not permitted to argue matters that are not in evidence. It is impermissible for an attorney to misstate evidence." The following day, counsel moved to re-argue the point, and there was a discussion. The judge asked, basically grilled defense counsel on what evidence there was on which he could base that argument that the gasoline can had been planted. The judge said that it would be very important if there was evidence, if the defendant had ever denied that the gasoline can was in his apartment. And it was actually pointed out to the judge that, by the prosecutor, in fact, that the defendant had denied that the gasoline can was in his apartment. Specifically, the defendant stated, "Why would I have gasoline in my apartment? I have no use for gasoline in my apartment." And the judge acknowledged that that was a denial, that there was gasoline in the apartment. So the judge denied the motion to re-argue, but he stated that he would give a corrective instruction. And defense counsel was very hesitant about the instruction, but eventually, after being given a well, do you want it or you don't want it type of statement from the judge, defense counsel agreed that there should be an instruction as suggested by the judge.
So did the judge agree that there was enough evidence from which an argument could have been made?
He never specifically said that. What he said was, he was initially saying what would be important is if there was a denial by the defendant. If there was no denial by the defendant, there's no basis for the argument. That's what the judge said. But even after it was pointed out to him that the defendant had made that denial, he didn't seem to acknowledge it.
But isn't he right for the wrong reason? How do you get from the evidence an inference that gasoline had been planted?
Well, it had to be either one way or the other. The defendant denied that the gasoline was placed that he had gasoline in his apartment. The police testified that there was gasoline in the apartment. Both can't be true. The jurors had to either decide that the defendant was lying,
the defendant didn't say there was no gasoline in my apartment. He answered with a rhetorical question.
Well, he actually said two things. He said, "Why would I have gasoline in my apartment? I have no use for gasoline in my apartment." And immediately when that was pointed out to the judge, the judge said, "Yes, I see that the defendant did deny."
Well, that may be a correct statement. He has no use for gasoline in his apartment, but that doesn't mean that he can't keep it there for some other use.
Well, I'd suggest, Your Honor, that
he really didn't deny. It wasn't an outright denial that there was gasoline in his apartment.
Well, on the other hand, Your Honor, it was certainly interpreted by the trial judge as a denial, and certainly could have been, and most likely would have been, interpreted by the jurors as a denial. It's the reasonable inference from those comments is the defendant is denying that he had gasoline in his apartment. I had no use to have gasoline in my apartment. So that's the reasonable inference that the jurors could be expected to draw, and the judge actually acknowledged that, but still did not back off what his disapproval.
So then the argument would be, if that's a denial that he had gasoline, that means that there was no gasoline in his apartment according to the defendant, and that if they found gasoline in his apartment, they must have planted it. That's the basis for the planting argument?
Well, exactly, that it has to be one or the other, that the jurors would have to believe the defendant's denial that there was gasoline in the apartment. He stated that he left the apartment, he had no key with him. The next people to be in the apartment were the police. So the two possibilities there are that the
the other possibility is that the police were lying, that there was no gasoline in the apartment. Isn't that really what it boils down to? You either believe one or the other. There either was gasoline in the apartment or there was no gasoline in the apartment.
But the testimony was that the gasoline was there.
And wasn't there a picture of gasoline? A big gasoline can?
Yes, there were pictures of gasoline cans in the closet inside the defendant's apartment, and a red gasoline can was recovered. And it was significant because there were the remnants of a red gasoline can were found in the house where the fire took place. And the defense was that wasn't my red gas can. The victim, the deceased, picked up that red gas can, and it was already in her home. That was the defense. So it had significance if the jurors believed that red gas can belonged to the defendant and was in his apartment before the police arrived.
Of course, the interesting thing about that analysis is that every time, in any case in which somebody says something was there and another person says, no, it wasn't there, it's no longer a question of credibility, but it becomes a question of planting. I mean,
well, not in every case, but in this, I would suggest that in this case it had to be one or the other. But the central point I'm trying to make is that defense counsel had the right to argue based on this evidence that it was planted. There were really only those two possibilities because the officers said they saw the gas can in the closet, presented pictures of the gas can in the closet. The jurors could either believe the defendant's denial that the gas can was that he had any use for gas in his apartment, or they could believe the police that they found.
No, I've not read the transcript. I assume the officers who did the search testified at trial.
Yes.
And with regard to the cross-examination of them, was there anything in the cross-examination that suggested that perhaps it was not there and that they had put it there?
Well, there was testimony about the fact there's a sort of strange detail here where the gas can appears to have been moved. It appears in two different positions in the photographs that were taken. So there was testimony about that. There was also testimony where one of the officers, Officer Dumas, appears to acknowledge that he was in the apartment before the officers arrived with the warrant. So there are some odd little circumstances, and that testimony I'd acknowledge I actually drop it in a footnote on page 20 in my brief. It's a compound question, but the officer appears to be acknowledging that he went into the apartment before other officers arrived. So there are bits and pieces.
For a judge who heard that testimony and that cross-examination, would any reasonable judge have inferred that there was any suggestion that they had planted the gas can?
There are those.
Phrased otherwise, did this allegation in closing argument come totally out of the blue, or was there anything in the evidence that suggested that it was coming?
Do you mean, was the judge taken by surprise by the argument? Possibly.
Would a judge or would a reasonable person under these circumstances, having heard nothing that suggested that it had been planted, view this as something totally out of left field?
Well, he heard the examination about he heard defense counsel trying to establish that officers went into the apartment before the warrant arrived, that there was this strange detail about the gas can being in different positions. So, but whether or not the judge would see this as coming out of left field, nevertheless, the argument was supported. The closest...
But wasn't the thrust of the defense a Bowden defense? The sloppiness of the police investigation, so that as the gas can appeared in two different positions in the closet, based on the thrust of the defense, the suggestion is that they were, you know, there was like the Keystone Cops. They were picking up the gas, they were moving it, they were taking pictures of it in a very haphazard manner. Wasn't that the thrust of the defense?
I don't think that was all there was to the defense. I think that it was clear that the defense attorney was suggesting that there was something underhanded going on by the police, as well as sloppy work. And whether or not the trial lawyer agreed that that was the case, or even if he found the argument to be offensive, which he obviously did, given the power of the instruction that he gave to the jurors, telling them they had to absolutely disregard it. Not just to disregard it, but telling them that there was no such evidence, no evidence of planting, even though the jurors heard the defendant deny that the gas can was there. So in effect, the judge told the jurors, you can't believe the defendant's testimony. That's a complete overstep by the judge. Whatever the judge thought of that argument, whatever he thought of the merit of the argument, it was for the jurors to evaluate it. It was for the jurors to evaluate whether the defendant should be found to be alive.
But I guess my concern is you have apparently, again, I've not read the transcript, defense counsel who holds his or her punches during the cross-examination, so the prosecutor never has a chance reasonably on rebuttal to ask the police officer whether or not he planted it. So you're essentially making an allegation which the prosecutor reasonably did not have a chance to address, and then in closing argument, when it's all too late, then suddenly you're making an argument, and it's almost as if the prosecution didn't really have a fair opportunity to be challenging a rather bold claim of police misconduct.
Well, Your Honor, I think when you do read the transcript, you'll see it was not an entirely a Bowden defense in the sense that the officers were being merely sloppy. There was a suggestion there by defense counsel that something devious was being done by the police officers. So no, I really couldn't agree that
Can I just clarify where I find that if I were looking in the transcript? Is it really only in when you went to the apartment, it was dark, and you went there and you took pictures? Is that where the focus is? Apart from the
well,
I mean, I get the part where there's been testimony that he didn't put it there. So I want to focus. Where would you focus for the planting that you say is there?
Well,
apart from I didn't do it.
Yes, of course. I've already said the number one focus is that I didn't do it, and
Right,
there were these other details, like Officer Dumas seeming to acknowledge that he was in the apartment.
Right, and that's the other one, right?
That and this kind of strange detail about which was verified by photographs of the gas can being moved into different positions with really no explanation for why that would be the case. Before the gas can was simply was recovered by the crime scene people. So there were additional matters, but I am frankly relying mainly on the defendant's testimony.
Was there any questioning concerning the movement of the gas can between the photographs, between the time the photographs were taken?
Yes, there was.
And did some police officers acknowledge that they had, taken the can out and then put it back into the closet?
Your Honor, I can't recall exactly what the testimony was about that. I know that I found it confusing. I was never really satisfied that there was an answer for that, why the gas can would have been removed before it was recovered. It was just another point that really just didn't seem to be resolved, or to the best of my recollection. I would like to point out that I'd like to talk a little bit about what the judge did as far as offering an instruction to defense counsel during his charge to the jurors, and what the judge said. Because the judge stated, if I instructed you to disregard statements of counsel, you must not consider that as a factor in your deliberations. I'd suggest that instruction is nothing but confusing. It's very difficult to know what to make of it, and not only that, the judge went on to say in the course of that instruction, the pressure and stress of trial may cause an attorney to make such a misstep. So again, the judge, rather than acknowledging an error, which was an error, he's continuing to insist that this was a misstep by counsel when it wasn't. And I'd suggest really that the only way that the judge could have cured this error was to acknowledge it to the jurors, to say, I was in error to tell you to disregard that argument. I was in error to say that there was no evidence to support planting. That's strictly for you, the jury, to decide. And I was in error for saying that that defense counsel did something that was improper. If there are no further questions.
Okay, thank you.
Thank you, Your Honors.
May it please the court, Catherine McMahon, Assistant District Attorney for the Hamden District for the Commonwealth.
You have to admit that the judge's so-called corrective instruction is a little bizarre.
It wasn't, the judge still found, after hearing the defendant's motion to be allowed to re-argue, he denied that. He found, and I think it's in volume 9 at pages 51 and 52, the inferences you suggest could be drawn are not necessarily reasonable inferences. I think that you invited speculation. He did not acknowledge that.
Look at the corrective instruction is, well, the judge may be wrong. Perhaps the argument was permissible. You must follow the judge's instruction. You are not to hold against either the defendant or the Commonwealth or to consider it during your deliberations. What the heck does that mean?
The judge did not find that defense counsel had made a permissible argument. He still held to that it was based on speculation and it was improper. I think the thrust of that corrective instruction was to tell the jury not to hold it against the defendant or defense counsel that he had been corrected by the judge. Not that it was improper for the judge to have corrected him, but not for the jury to infer that defense counsel or the defendant had done anything wrong, but to still disregard the evidence or the argument that the judge found to be impermissible argument. So it wasn't meant to bring back what he had stopped defense counsel from doing because he never found that that was proper argument. He concluded that it was based on speculation.
So was there a flavor to the defense as a whole that went beyond the Bowden defense? Was there a suggestion or innuendos in cross-examination that the police were doing some underhanded things with respect to the defendant, purposefully underhanded?
About 20 minutes after the fire, police officers found the defendant on the street, and the defendant's statements to them came into evidence. For that, defense counsel was asserting that the police officers were not truthful about the defendant's mental condition, about his physical condition, about the voluntariness of what he said, and even about the fact that they found matches in his pocket because the defendant had badly burned hands. How could he have possibly put his hands into his pocket after starting the fire and being burned? So in that respect, about that aspect of the Commonwealth's case, he was saying that the police officers were untruthful. The rest of it, from his opening and through most of his closing argument, was a Bowden argument. The judge gave a Bowden instruction. It was to the effect that the police were so sympathetic to the burn victim, the murder victim, that they stopped investigating there and just went and ignored things. They didn't recover certain things from the apartment that had been burned that he contended would have bolstered the defendant's statement and been helpful to the defense. They hadn't searched the apartment thoroughly. The dog only went to where the dog smelled gasoline or an accelerant and didn't go to a back area, like a storage area of the apartment where the defense counsel suggested there may well have been gasoline stored, and maybe where the alleged victim had obtained the gasoline that the defendant alleged she had thrown at him, and it was ignited and set her on fire. So, but in terms of the search, Officer Dumas did not say that he was there first. He thought he was there after other police officers. And what defense counsel did was not to suggest that people were lying in his cross-examination, but this had been a retrial. Several years had passed. People weren't sure about exactly what time they went, so people had Dumas, who took a photograph of the outside of the building. It doesn't show the sky, but it shows lights on in the building. Says it was, I got there towards morning when it was still dark. The search warrant was executed at 8:30 a.m., even on January 7th, where daylight would be after 7. That'd be something that jurors could take as common knowledge. By 8:30, it would have been light out, but the photograph doesn't show the sky. The police officers and troopers couldn't remember exactly who was there when. Trooper Mazda, who was there with the dog, who discovered or alerted to the gas can in the closet, thought that everybody who executed the search warrant arrived together and that it was daylight. Dumas said he wasn't the first person there, but he thought he got there when it was still dark out. And then there were different photographs put in by the prosecution and the defense of the gas can in the closet. And the nozzle is facing one way in 2 photographs and another way in a 3rd photograph, photographs taken by different people, but Detective Strout testified that he picked up the gas can and took off the nozzle. That 2 of the photographs were taken before he picked it up. So there was testimony, and I think that came in the defense's case, that during the search, the dog Milo discovered the gas can, photographs were taken, one of the police officers picked it up and removed the nozzle before putting it back. So that was the state of the evidence, and for the judge, it's clear from page 51 of volume 9, the argument that defense counsel made came to him completely out of the blue. He did not get those inferences. No police officer was questioned about, did you bring a gas can with you? You planted it there. Nothing to that effect. It was just based on inconsistencies in timing and how daylight it was. And from that, he didn't just say they planted the gas can. He said they made an illegal entry into the defendant's apartment before they obtained the search warrant so that they could plant the gas can, and that they directed Officer Dumas to take photographs before they decided upon the final placement of the gas can. So that was, if you're dealing, and he also suggested that the police had stolen or taken the gas can from possibly the fire department because there was a generator in use by the fire department trying to extinguish the fire, and there was a gas can depicted in the photograph of the generator that was used by the fire department. So he suggested that they took the gas can. There's no evidence of that. There was no questioning on that they made an illegal entry, that there were 2 entries into the defense department, one with the warrant and one before that where they planted the evidence, and that they had a police officer take photographs before they decided on the final positioning. And that is beyond inferences, fair inferences. That's utter speculation. And he did it in a way we know that they planted it. We know that they went in the dead of night. And the trial judge took that as an assertion of his personal expression of his personal belief. And he found that the inferences were speculative. And he stayed with that. The corrective instruction was to not take any further bad inference against defense counsel because he had stopped his improper argument. But he never said it was a proper argument. He found that it was speculative. And he was there, he heard it, he had heard all the evidence. It came out of the blue to him. He found it was unwarranted and an unfair inference, and he did not err in stopping the improper argument here. I note that he also had to give a curative instruction to the jury about 2 statements that the prosecutor made in his closing argument. So when he told the jury that he had to correct passionate closings, but not to hold it against counsel, he'd also corrected the prosecutor for referring to something that had been deliberately excluded from evidence, and from also arguing that the victim's family were credible simply because they subjected themselves to cross-examination. So in that sense, both counsel were reprimanded. Both counsel had instructions to the jury saying that their arguments were somewhat improper. And so it wasn't that he came down only heavily on defense counsel and deprived the defendant of defense. He still launched a Bowden defense. He got a Bowden instruction. He was allowed to argue that the police were lying about the defendant's physical and mental condition at the time that he made his admissions 20 minutes after the fire. And also, this is a case of overwhelming evidence of the defendant's guilt. It's not simply that the jury found the defendant guilty under all 3 theories of first-degree murder, but there was overwhelming evidence under all 3 theories. He was known to the victim and the victim's family. They saw him come into the house. They broke in angrily, saying angry things at him while sprinkling gasoline around. The forensics showed that gasoline was where the defendant's path of travel had been. He admitted that I'm the one who started the fire. A police officer noticed he reeks of gasoline and says that. He goes, that's what I used to start the fire with. They find matches in his pocket. That's what I used to start the fire with. The victim in the ambulance said he threw gasoline all over me. So she didn't say his name, but it was thrown at her. It wasn't that she caught fire in a fire that was set. He set fire to her. So there's deliberate premeditation. There's extreme atrocity or cruelty. He's already been convicted of armed home invasion based on this. That was the basis of the felony murder, first-degree conviction. And based on all of this, using your powers under 33E, you should affirm the conviction and not reduce the verdict.
Now, is this a matter of form in the sense that if the defense counsel had said, you heard my client deny that the gasoline container was his, I asked you to consider if it was not his, and if he didn't put it there, who did? Would that have been a different, would that have been a permissible argument?
Because it wasn't this, I was there, it was a very forceful argument. We know they went in there and they planted it. We know that they had Officer Dumas take pictures before they decided on the final placement of it. We know it wasn't simply a suggestion or an inference, it was a declaration of fact based on, I say, surmise, not reasonable inferences. If you have no further questions, I'll rest on my brief.
Thank you.
Thank you.